I think this is your chapter 1 of unit 4, if I'm not wrong. Right, so okay, so let's start. Wait, this is not working. ये जितने भी सेशंस मैं ले रही हूँ, जितने भी सेशंस आपको यहाँ पे पढ़ाए जा रहे हैं, ये बोर्ड्स पॉइंट ऑफ व्यू से बहुत ज़रूरी हैं, right? And I make it my point to discuss only those topics which are important for your long answers and short. हालांकि बोर्ड्स में लॉन्ग शॉर्ट आंसर्स के बीच में चॉइस आती है, लेकिन फिर भी कुछ टॉपिक्स ऐसे हैं जो ज़्यादा स्कोरिंग होते हैं और वो आपको ज़्यादा मार्क्स दिलवा सकते हैं, राइट? एंड बोर्ड्स इज ऑल अबाउट मार्क्स. So boards is all about marks, and that is what all of us are aiming, right? So be very attentive during these sessions and try to make notes also. Let us start. Okay, so everyone knows that we have an all India mock that is going to run from 25th August till 3rd of September. It is a very important and a very unique opportunity of you to compete with your peers. Hold on, guys. राइट, सो हाँ, 25th अगस्त से लेकर 3rd सितंबर तक ऑल इंडिया मॉक रन करेगा. बहुत कम ऐसी अपॉर्चुनिटीज मिलती है जहाँ पे आप एक्चुअल कंपटीशन सिमुलेशन में बैठ सकते हैं. मॉक्स आर मोर पर्सनलाइज, राइट? वहाँ पे कोई और आपके साथ compete नहीं कर रहा होता, लेकिन इन सेशंस में देयर इज द एंटायर कंट्री competing against you, right? So it is like an actual exam. तो एग्जाम से पहले अगर आपको इस तरह की प्रैक्टिस मिल रही है तो आई वुड सजेस्ट दैट यू गो फॉर इट. ओके, नाउ दिस इज व्हाट the content is. Administration of criminal justice is carried out through magistrate courts and sessions court. दो लेवल होते हैं ऊपर कोर्ट में, right? There are two levels. District level is same as sessions level, right? District और sessions का एक ही लेवल होता है, लेकिन district जो मैटर होल्ड को लेता है वो सिविल के होते हैं और सेशंस के पास क्रिमिनल के मैटर जाते हैं, राइट? लेकिन दोनों का जो हायरार्की है, जो स्टेटस है, वो बिल्कुल इक्विवेलेंट होता है. इंडियन पिनल कोड, आईपीसी, कोड ऑफ क्रिमिनल प्रोसीजर, सीआरपीसी एडमिनिस्ट्रेशन ऑफ और एनफोर्समेंट के लिए है. आईपीसी लेज डाउन द लिस्ट ऑफ ऑफेंसेस विच आर punishable in India. Then criminal procedure code lays down the process of filing the FIR till the time of judgment. तो पूरा का पूरा criminal administration function में कैसे आता है, how does the machinery of criminal administration start working, everything is laid down in the code of criminal procedure. Then we have Indian Evidence Act that guides the process of trial as to what evidences are admissible and what are not. Right, तो trial के process में criminal jurisprudence, the trial, whether it is civil or criminal, is all about evidences. A person accusing another person of something and the person proving the allegations. That's how it goes. तो एलिगेशंस के सिनेरियो में भी, एक्यूजेशंस के सिनेरियो में अगर गिल्ट प्रूव करनी है तो वो किन किन तरीकों से की जा सकती है. देयर आर सम एविडेंसेस व्हिच आर एडमिसिबल व्हिच कैन prove the given fact and situation, but there are certain evidences which are absolutely not admissible in the court of law, right? तो ये पूरी की पूरी जो कहानी है कि भाई कौन सा एडमिसिबल है एविडेंस जो कोर्ट एक्सेप्ट करेगा, किस एविडेंस की क्या वैल्यू है, कितना सिग्निफिकेंट है, कितना नॉन सिग्निफिकेंट है, एविडेंशियरी वैल्यू के पॉइंट ऑफ व्यू से किस एविडेंस की प्लेसमेंट ज्यादा है, किसकी कम है, एवरीथिंग रिलेटेड टू दिस इज डिस्कस्ड इन इंडियन एविडेंस एक्ट. ओके, then these are the categories of criminal courts in India. Courts of Session, Section 9 of CRPC provides for the establishment of Sessions Court, and it provides that every state government has to build a session or establish a Sessions Court for every division. मतलब हर district के लिए एक Sessions Court होता है. तो if you have a district, there would be one district court. One district, one Sessions Court. That's how the rule is. That's what Section 9 of the CRPC provides. there is a judge who presides over it and he is appointed by the High Court. It can impose any punishment including the capital punishment. तो सेशंस कोर्ट की जो पावर होती है वो काफी हाई होती है. It can even pass a death warrant to a criminal. But according to section 366 of the CRPC, the same court, it provides कि अगर district court या sessions court से कोई भी capital punishment निकल कर आता है, it cannot be executed just because the district court has passed it. It would first be confirmed by the high court. तो अगर कोई भी capital punishment आता है district court से, तो पहले वो high court में जाता है. Facts and circumstances evidence examination के बाद अगर high court को लगता है कि हाँ sessions court का फैसला सही था, तब उस capital punishment को confirm किया जाता है. Although this capital punishment can be appealed also in the High Court. So that's how it goes. Now CJM and ACJM, basically Chief Judicial Magistrate and Additional Chief Judicial Magistrate. These are Judicial Magistrate of first class is the Chief Judicial Magistrate. Every district, not being the metropolitan area, there are Judicial Magistrate of first class. एक डिस्ट्रिक्ट में एक सीजीएम नहीं होता, मल्टीपल होते हैं. They are appointed by the High Court. Again, they have a limited power. They can provide any sentence except the sentence of death, and the capital punishment also cannot exceed beyond 7 years. Right? So, imprisonment of life or 14 years होता है actually CGM का. This creates a problem. सीजीएम कोई भी पनिशमेंट पास कर सकते हैं, राइट, लेकिन वो डेथ पनिशमेंट नहीं पास कर सकते, और मैक्सिमम इम्प्रिजनमेंट भी जो दे सकते हैं वो 14 ईयर से ज्यादा नहीं हो सकता. लाइफ इम्प्रिजनमेंट की जो टोटल यूजुअल प्रैक्टिस है वो भी 14 ईयर्स ही होती है. लाइफ इम्प्रिजनमेंट डजंट मीन अ रिमाइंडर ऑफ अ पर्सनस लाइफ अनलेस इट इज स्पेसिफाइड specially by the Indian Penal Code that life imprisonment would mean the remainder of a person's life. जब तक ये नहीं लिखा हुआ तब तक section 57 Indian Penal Code लगता है. And life imprisonment generally holds for 20 years. मतलब life imprisonment के अंदर अगर आप किसी को punishment दे रहे हैं तो मैक्सिमम 20 साल तक की सजा हो सकती है उसको. एक कॉमन प्रैक्टिस जो है, जो 20 साल तक नहीं है और 10 साल से ऊपर है, उसे 14 में ला दिया गया है. तो यूजुअल जो सेंटेंस मिलता है लाइफ इम्प्रिजन में वो 14 इयर्स होता है, जो आपने सुना भी होगा. A chief judicial magistrate subordinate to the session judge and every other judicial magistrate is subordinate to the chief judicial magistrate. Okay. Now we have a workshop on 27th of August, which is tomorrow, right? And it is to be conducted at 6 p.m. And it is going to give you a strategy of what to do in these coming 100 days, right? So how to balance out these 100 days, कैसे marks करने हैं, क्या सब कुछ अभिमन्यु सर आपसे discuss करेंगे इस workshop में. Now courts of judicial magistrate are defined or provided by section 11 of CRPC. Again, these are sections. I mean, it's a good thing if you remember them and you mention them in your answers. But if you cannot, just mention CRPC provides for this. CRPC provides for that. Although, you know, since it is a humanities stream, legal studies is a part of humanities, and there's a lot of things that you guys are expected to remember. Sections are one of them, right? So section 11 is something that you should remember. Section 11 of the CRPC provides that every district court, not being a metropolitan area is also defined by the CRPC. I think it is defined under section 10, and it defines metropolitan area to be an area with a population of more than 10 lakh, a million, right? वो metropolitan area होता है. So section 11 of CRPC, every district not being the metropolitan area, there shall be courts of judicial magistrate of first class and second class. Section 15 provides that the judicial magistrate is subordinate to CJM. Section 29 provides that a judicial magistrate of the first class may pass any sentence of imprisonment for a term not exceeding 3 years or a fine not exceeding 10,000 rupees or both. Judicial magistrate की जो power है, you know, in terms of penalizing someone or giving somebody a punishment, it is limited. He can only provide or imprison or pass sentence which can exceed till 3 years. Judicial magistrate first class can only pass the sentence of imprisonment which is maximum of 3 years. The fine that he can impose can maximum be of 10,000 rupees. Judicial magistrate second class का और कम है. He can only pass a sentence of imprisonment which can be maximum 1 year. Judicial magistrate second class can try the offence if it is punishable with imprisonment not exceeding 1 year and fine not exceeding 5,000 rupees or with both. First class magistrate competent to try offences punishable with imprisonment for not exceeding 3 years or with fine up to 10,000 rupees. Right? So basically इस तरह से ये उसी कैटेगरी इस चीज पे डिफाइन नहीं होती कि भाई हम कितना पनिशमेंट पास कर सकते हैं. पनिशमेंट देना जुडिशियल मैजिस्ट्रेट का पर्सनल डिस्क्रेशन नहीं होता है. पनिशमेंट आप वही दे सकते हो जो कोड में लिखा हुआ है. इंडियन पीनल कोड नॉट ओनली प्रोवाइड्स द लिस्ट ऑफ ऑफेंसेस, it also provides the penalty that entails if you commit that offense, right? तो जुडिशियल मैजिस्ट्रेट फर्स्ट क्लास उन्हीं पनिशमेंट्स को ट्राई कर सकते हैं जिनका पनिशमेंट 3 साल से ज्यादा नहीं है. मतलब वो पनिशमेंट भी अगर दे रहे हैं किसी ऑफेंस का तो वो भी 3 साल से ज्यादा नहीं हो सकता, राइट? उसी तरह से जुडिशियल मैजिस्ट्रेट सेकंड क्लास कैन ओनली ट्राई ऑफेंसेस व्हिच आर पनिशेबल फॉर नॉट मोर देन 1 ईयर एंड व्हिच हैव अ फाइन फॉर नॉट मोर देन 5,000 रुपीज. फाइन को नहीं डिफाइन किया हुआ है आईपीसी में, बस फाइन लिखा हुआ है, देयर इज नो अमाउंट दैट इज लिस्टेड. लेकिन सीआरपीसी में कितना फाइन इम्पोज किया जा सकता है ये भी बताया गया है. जैसे जुडिशियल मैजिस्ट्रेट फर्स्ट क्लास जो है 10,000 से ज्यादा का फाइन नहीं लगा सकते. जुडिशियल मैजिस्ट्रेट सेकंड क्लास 5,000 से ज्यादा का फाइन नहीं लगा सकते. सीजीएम, डिस्ट्रिक्ट कोर्ट, हाई कोर्ट, सुप्रीम कोर्ट, इनके पास कोई पावर नहीं, मतलब इनकी जो पावर है वो अनलिमिटेड है, कितना भी फाइन ये लगा सकते हैं. Now we have metropolitan magistrates, the towns having population exceeding 1 million, like I said. Under the general control of the sessions judge, metropolitan area भी session judge के control में ही होता है, and he is subordinate to the chief metropolitan magistrate. Okay, he is not subordinate to the chief metropolitan magistrate. CMM और CJM almost equal हैं, almost क्या equal ही हैं. So CJM is equal to CMM. वो चीफ जुडिशियल मैजिस्ट्रेट है क्योंकि वो जुडिशियल डिवीजन है, मेट्रोपॉलिटन डिवीजन है, तो यहाँ पे जो मैजिस्ट्रेट होते हैं वो मेट्रोपॉलिटन मैजिस्ट्रेट कहलाते हैं. जुडिशियल मैजिस्ट्रेट्स मेट्रोपॉलिटन एरियाज दिल्ली वगैरह में एमएम कहलाते हैं, मेट्रोपॉलिटन मैजिस्ट्रेट्स. ओके, so there's when it comes to power status and the power of giving sentences etc, the power remains the same, कुछ भी ऊपर नीचे नहीं है. The only thing that differs is the name. Then we have executive magistrate. Executive magistrates are separate than judicial magistrate. जैसे कि district magistrate, as sub-divisional district magistrate, right? जो central government के employees होते हैं. They cannot adjudicate on the matters. They definitely can pass orders, etc. जैसे section 144 CRPC, which is an order of curfew, is passed by an executive magistrate, not by a judicial magistrate. तो आपने सुना होगा किसी भी डिपार्टमेंट में जो कमिश्नर्स होते हैं, जॉइंट कमिश्नर्स, असिस्टेंट कमिश्नर, चीफ कमिश्नर, इनका जो लेवल होता है वो एग्जीक्यूटिव मैजिस्ट्रेट का होता है, बिकॉज दे कैन पास ऑर्डर्स, और ये ऑर्डर्स हाई कोर्ट में जाके कंफर्म होते हैं, राइट? So they are known as district magistrate, DM, sub-divisional magistrate, SDM, executive magistrate, special executive magistrate. They are appointed by the state government in every metropolitan area. Generally जो DM और SDM होते हैं वो तो आपको पता ही है कि competition से जाते हैं, and they are the employees of central government. State government के employees नहीं होते हैं. Their job is to maintain law and order, traffic challans, registration documents, etc. These are the types of offences, bailable and non-bailable offences. So bailable offences are generally the offences where a person has a right to be released on bail, right? So as soon as he is put into custody, he can furnish a bail bond and he will be immediately released. तो bail furnish करना और custody से release होना उसका right है जो वो exercise कर सकता है. Non-bailable offences थोड़े serious offences हैं where the punishment goes beyond 3 years and the bail does not come as a matter of right. So the discretion to pass bail rests with the court. A person cannot avail it as a matter of right. He may apply for a bail in the respective court, and whether he should get bail or not would be decided by the judge. He cannot demand it. बेलेबल ऑफेंसेस में ही कैन डिमांड इट एंड ही विल बी गिवन। यहाँ पे कोर्ट का कोई डिस्क्रेशन नहीं है। बेलेबल ऑफेंसेस में अगर बेल फर्निश होती है तो पुलिस ऑफिसर को छोड़ना ही पड़ता है, कोर्ट का इंटरफेरेंस नहीं होता है इसमें। नॉन बेलेबल ऑफेंसेस में पूरी की पूरी एप्लीकेशन जाती है कोर्ट में, हियरिंग वगैरह सब होती है और फिर कोर्ट डिसाइड करता है कि आपको बेल मिलनी चाहिए या नहीं। Anticipatory bail. Anticipatory bail basically is a kind of bail that a person takes in advance. So if a person is anticipating arrest, means that he thinks he might be arrested for a non-bailable offense in future, then he can apply for a bail in advance. This bail hearing is a proper hearing where he has to prove that why he should not be taken into custody, why the case is a frivolous one, and why he is innocent. Everything needs to be proven beforehand. Public prosecution, everyone gets involved. And after the court is, satisfied with the fact that yes, the person should be granted an anticipatory bail, that person is granted the anticipatory bail. अब इसका result क्या होता है? Anticipatory bail doesn't mean that the person will not be arrested. Of course, the order of arrest, the order of taking the person into custody can very well be passed, but the order will not be executed. तो पुलिस अगर आपके दरवाजे तक आई भी है तो वो आपको लेके नहीं जा पाएगी। तो ये अरेस्ट से इम्यूनिटी नहीं होती है, कस्टडी की इम्यूनिटी होती है, राइट। तो अगर अरेस्ट वारंट आता भी है और आपको ले जाने के लिए पुलिस आ जाती है, ऑब्वियसली आपको ले जाया जाता है, अरेस्ट करते हैं जब, तो आप अपना एंटिसिपेटरी बेल दिखा सकते हैं और आपको कस्टडी में लेके नहीं जाया जाएगा, पुलिस खाली हाथ लौट जाएगी। ये एंटिसिपेटरी बेल का आफ्टर मैथ होता है। ओके, तो anticipatory bail can only be applied for in the sessions court or the high court, even the Supreme Court, if it is rejected in the high court. The court may consider the following aspects when the application for anticipatory bail is considered. The first are the nature and gravity of the accusation, the antecedents of the applicant, meaning thereby what his past is. Has he committed an offense before? Was he tried before? So how is his standing in the society? Everything, old age, etc. is taken into consideration. Possibility of him fleeing from a justice. If there's a possibility that he might not cooperate in future or he might abscond if there's a criminal process in motion, then of course the bail may be denied. Again, if the accusation appears to be aimed at humiliating the applicant, if the application on the face of it, the court is satisfied that the only reason why the case was lodged in the first place was to seek vengeance or to humiliate the accused, यहाँ पे anticipatory bail grant हो सकती है। कब कहाँ से आएगा? Anticipatory bail is one of the topic in this unit, so that is why we are discussing it. Cognizable, non-cognizable offenses का direct जो relationship है वो bailable offenses से है। Cognizable offense is an offense where a person can be arrested without a warrant. So arrest basically is denying a person or violating his right to life and personal liberty, which is guaranteed under Article 21 of the Indian Constitution. It is the most sacred right that the Constitution provides us, and to violate it, there has to be a very strict process to be followed. And one of the processes is the categorization of offenses into cognizable and non-cognizable. So if a police officer wants to arrest a person for interrogation, investigation, or for whatever reason, he needs to obtain a permission from the court, and that permission is called a warrant. Now, if he attains a warrant, he can take the person into custody. But in every case, he doesn't have to take a warrant. For example, let's say that the crime is heinous and the criminal is equally serious. He is a very, hard-bent criminal who has done several offenses before. He is influential and everything. And there might be a chance that he flees, absconds, and the criminal process will come to a halt. Now, in order to, punish the criminal and to provide justice and everything, the person needs to be in custody at an immediate effect. Now, in that kind of case, taking a warrant might delay the process, and that is why the police officers have been given the permission to arrest without a warrant. Now, this permission is granted in certain kind of offenses जहाँ पे बिना warrant के arrest की जा सकती है, और उन्हीं kind of offenses को हम cognizable offenses कहते हैं। और वो ऑफेंसेस जिनमें अरेस्ट बिना वारंट के नहीं की जा सकती वो नॉन कॉग्निजेबल ऑफेंसेस होते हैं, राइट। Compoundable, non-compoundable offenses. Compoundable offense is an offense which can be settled out of court. So let's say that, there is a matter of theft and the amount was not much. The theft complaint of is of 10,000 rupees and that's it. But the thief says to the thief tries to make peace with the person who has lodged the FIR that if you take back the complaint, I'll return your money and I'll also provide you with compensation. Now, it's a win-win situation for the party. Obviously, he does not have to follow the tiresome process of the court and he gets his money back. So, there's no harm. Now, a situation can arise like this where people or parties might want to settle out of court, right? Take and give whatever it is to withdraw the complaint and settle the matter once and for all. Because the process of court will take a very long time to come to a conclusion. Now, the matters which can be settled like this are called compoundable offenses. These are generally non-serious offenses, property-related offenses. But there are offenses whose out-of-court settlement is absolutely not allowed for public policy or public morality reasons. And those are called non-compoundable offenses. For example, rape, murder, etc. Now, in these cases, if parties are, given the opportunity to settle outside of court, the victim will never get justice. So, the list of compoundable offenses or non-compoundable offenses is given in section 320 of IPC, if I'm not wrong. Right, so section 320 of IPC provides for the entire list of compoundable offenses, the offenses that can be compounded. The offenses which are not given in that list are non-compoundable in nature. Okay. So everyone knows that we have launched series. There are crash courses, there are comprehensive courses, test series. Everything you can take a demo of by just downloading the app and availing a free trial for 3 days. Criminal investigation and first information report. FIR, everyone knows criminal investigation. The process of criminal investigation actually begins after the FIR is launched. It is first information report. The first report or the report that introduces or, presents a crime or tells the information or informs about a crime in the first instance. तो पहली बार क्राइम कमिट होने की इंफॉर्मेशन जब आती है और जैसे आती है उसे फर्स्ट इंफॉर्मेशन रिपोर्ट कहते हैं. जब बदलेगा तब बदलेगा, अभी तो पढ़ना ही है, राइट. सो फर्स्ट इंफॉर्मेशन रिपोर्ट इज प्रोवाइडेड फॉर, नॉट डिफाइंड, provided for in section 154 of the CRPC. It provides how the process goes. So a person goes to the police station, narrates the entire incident, whether it is a first-hand narration or a second-hand narration. The agenda is to report the police about an occurrence of a crime so that the machinery can start moving. Right, the moment first information report or the FIR is lodged, the police becomes active and the investigation, etc. starts. At the end of the investigation, if the police is sure that yes, the crime was committed and these are the evidences that show the commission of the crime, they file a charge sheet. The charge sheet is submitted with the court and then the trial begins. That's how the process goes, right? So the FIR is not an evidence. So, but if there are loopholes in the FIR, for example, if the statements are not consistent and there are inconsistencies, for example, the person said something in the FIR, something else in the interrogation, absolutely something else in the testimony before the court. So of course you can corroborate or use the material in the FIR to corroborate it with the other evidences. In all, like in individually it is not a piece of evidence, लेकिन इसे बाकी evidences के साथ compare किया जा सकता है facts and circumstances की clarity के लिए. Okay. So whoever lodges the FIR has to sign on it and he is given a copy of the FIR for free. Police cannot charge it. And in Lalita Kumari versus State of UP, it was confirmed, declared by the Supreme Court that police does not have a discretion to decide whether or not to lodge an FIR. If a person comes to report a crime, it is mandatory on the police to report it, to incorporate it in the register. उनकी मर्जी है तो वो FIR करेंगे, मर्जी नहीं है तो FIR करेंगे, ये नहीं चलता. ये उनकी ड्यूटी है, ये मैंडेटरी है कि जो भी इंफॉर्मेशन आ रही है क्राइम की, इमीडिएटली उसे रजिस्टर किया जाए ताकि मशीनरी काम कर सके. राइट. Original FIR is sent to the magistrate. It also becomes part of the entire charge sheet that is prepared later on. Police officer refusing to register an FIR, the aggrieved can send it to the superintendent of police. But if at all the police officer is acting stubborn and he's not registering the FIR for whatever reason, a complaint can directly be sent to the superintendent of police, who will then take an action. FIR is immediately made after the occurrence of an incident. Telephonic information can also become an FIR if a person is reporting a crime through telephone. Okay. But a cryptic information will not be an FIR. So if an information is lodged through telephone and it is cryptic, like it does not really mention the time and place and the people involved, and later on that a proper FIR is filed, then the cryptic information will not be considered as an FIR. Right. So whatever supports the criminal machinery more is to be considered. So if the telephonic conversation is a substantial piece of information that can tell the police if a crime is committed, then that information can also be taken into consideration. Victim can also file his complaint in the police station, and if, for example, if a crime has happened at a place where the person is not present, for example, how should I say, let's say that I went to Kerala, okay, and something has happened back home. Now I cannot immediately come and I would be here for some time. So what I can do is I can lodge an FIR in Kerala only, and my home is in UP. So the Kerala police will record the FIR and transfer it to the UP police so that they can start working. This kind of FIR is called zero FIR. Okay. तो आपको क्राइम का कहीं भी किसी भी सूरत में पता चले, आप नजदीकी पुलिस थाने जाके इंफॉर्मेशन रिपोर्ट कर दीजिए इमीडिएटली. वो किस पुलिस थाने में ट्रांसफर होनी है वो अपने आप देख लेंगे. आपकी ड्यूटी है कि आप क्राइम की रिपोर्टिंग इमीडिएटली करें. ओके. तो ये जो मूवी में देखते हैं कि भाई उस पुलिस थाने चले गए, वो आपसे कह रहे हैं कि अरे यहाँ का तो जुरिस्डिक्शन ही नहीं है, द्वारका जाइए. द्वारका वाले कह रहे हैं कि नहीं पटेल नगर चाहिए. ये असल में होता भी है बट ये सही नहीं है. दिस इज एक्चुअली वायलेटिंग द प्रोसेस बिकॉज दे हैव टू रिकॉर्ड द इंफॉर्मेशन वेर एवर दे आर एंड देन ट्रांसफर इट टू द appropriate police officer or the appropriate police station. तो ये आदमी का काम नहीं है कि वो जगह जगह भागे FIR दर्ज कराने के लिए. जो सबसे नजदीक में है पुलिस स्टेशन वहीं करवाओ और वो पुलिस स्टेशन दूसरे पुलिस स्टेशन में ट्रांसफर कर देगा. ये एक्चुअल प्रोसेस है. अब ये लोगों को पता नहीं है तो वो पुलिस के हाथों एक्सप्लॉइट हो जाते हैं. आप लोगों को पता चल गया है, इसे ध्यान रखिएगा. Information to the police as to non-cognizable offense. If any person gives information to an officer in charge, which is a station house officer, SHO, about the commission of an offense which is non-cognizable, where an arrest cannot be made without a warrant, a non-serious offense, तो यहाँ पे FIR नहीं होती है, यहाँ पे NCR लॉन्च की जाती है, नॉन कॉग्निजेबल रिपोर्ट. राइट. तो यहाँ पे पुलिस के इन्वेस्टिगेशन की या एक्सेसिव इंटरफेरेंस की जरूरत नहीं होती है. पुलिस का काम बस इतना है कि भाई NCR को रिकॉर्ड कर लिया जाए. इसके आगे की ड्यूटी कोई नहीं होती पुलिस की. इन्वेस्टिगेशन, इंटेरोगेशन एटसेट्रा, ऑल दैट द कोड ऑफ क्रिमिनल प्रोसीजर एंटेल्स. But if there is something that the police has to do and they are not doing it, a complaint can be made to the magistrate and the magistrate can further order investigation. NCR रिकॉर्ड होने के बाद सीधा कोर्ट में जाती है और कोर्ट से प्रोसेस शुरू होता है. पुलिस का इसमें इन्वॉल्वमेंट नहीं होता. कोर्ट में जाने के बाद अगर कोर्ट को लगता है कि ये यहाँ पे तो इन्वेस्टिगेशन करनी चाहिए थी, तो कोर्ट इन्वेस्टिगेशन ऑर्डर कर सकता है. ओके. अरेस्ट एंड राइट्स ऑफ द अरेस्टेड पर्सन. सेक्शन 57 से 167 तक राइट्स दे रखे हैं. The accused has to be produced with the magistrate within 24 hours of the arrest, वरना illegal detention हो जाता है. Section 167 clause 3 also provides that the investigation has to be concluded within a certain time frame. So if it is not concluded within a certain time frame, even in non-bailable offences, a person may get a right to bail, will get a right to bail. He shall be released on bail, and that kind of bail is called default bail. Right. If the investigation is not concluded within the time, the police may order police custody. Section 50 of the CRPC. The person has to be arrested. The person who is arrested has to be informed of the grounds of his arrest. Right. तो इन्वेस्टिगेशन अगर टाइम से कंक्लूड नहीं होता है तो मजिस्ट्रेट पुलिस कस्टडी ऑर्डर कर सकते हैं, जुडिशियल कस्टडी ऑर्डर कर सकते हैं, वॉट एवर इज रिक्वायर्ड. ओके, पुलिस कस्टडी कैन मैक्सिमम बी ऑफ 15 days. जुडिशियल कस्टडी भी अनलिमिटेड नहीं हो सकती, लेकिन हम सबको पता है कि पेपर पे क्या लिखा है और एक्चुअल में क्या होता है. The Supreme Court has also recognized the right of an arrested person to have access to a lawyer in the case of Nandini Satpathy and D.K. Basu. Now it is a recognized right given in CRPC, where a person has a right to avail the lawyer of his choice. And if he cannot afford a lawyer, then the state government will provide him with one. Okay. Investigation, inquiry and trial. Investigation means when a police officer investigates or looks into a matter. Inquiry is when the police officer finds that there is no offense that he needs to report, and he needs to report to the magistrate who should drop the proceeding. But magistrate feels otherwise, he can ask the police officer to look into the matter a little bit more, and that is what we call an inquiry. Trial basically is the process of the court where the guilt and innocence of the person is adjudicated based on the evidences that are presented in the charge sheet or what the lawyers are going to present in the trial. The entire process is called trial. Okay. The result of the trial is either acquittal or conviction. A person may be declared innocent or he may be punished according to the evidences. Warrant, summons and summary trial. Warrant is, I told you, is an arrest order passed by a magistrate. Summons is basically a notice sent to a person through court which demands an appearance. That is summons. Summoning is basically to call someone. So that's exactly what summon is in legal fraternity also. So when a person is respectfully asked to join the court proceedings, he is summoned to the court. Summary trials basically are the trials that do not need to face a trial basically, right? A mere complaint and the, appearance of the party is also not necessary. One single hearing and the matter can be disposed quickly. Those are called summary trials. So matter which do not have much value, whether crime or anything, they do not require too many evidences. The person has admitted to his guilt, is ready to settle, etc., can be disposed of through a summary trial. These are the distinct stages of criminal trial: framing of charge or issuance of notice, then the recording of prosecution evidences. First, the charges are framed according to what the charge sheet entails. Then the notice is issued to the parties according to the charges that they have been, alleged against. Then the prosecution evidence is recorded, the second stage. The third stage requires the statement of the accused. Then the accused presents the evidences to rebut prosecution evidences. Finally, there are arguments, and after which there is a judgment. This is age and criminal liability. Up till 7 years, it's doli in capex, so there is no criminal liability. 7 to 12 is doli capex, where the liability would be determined as per the maturity level. So if a child is mature enough to understand the implications of his acts and the consequences, then he may be implicated or tried as a juvenile. Teenagers basically are held under Juvenile Justice Act. The punishment is not too aggressive, right? And they are the entire idea is to try to make them come to a better path, or to, what should I say? To make them a proper human being, to take them out of the criminal, marsh. Above 18 years are adults and they are properly liable for everything that IPC stands for. The function and role of police is these are the following. There's not much to explain here, but I can just read and explain a little. So the first role is to uphold and enforce the law impartially to protect life, liberty of the public. इसको ऐसे ही आप लिख सकते हैं. This can be your long answer or short answer. ये long answer है वैसे. Function and role of police. You can write the same and explain it a little bit in your words, and you have a full-fledged answer. Then to promote and preserve public order, to protect internal security, prevent and control terrorist activity, breaches of communal harmony, militant activities, other situations affecting internal security, protect public against acts of vandalism, violence, and any kind of attack. To prevent crimes, reduce opportunities for commission of crime through their own preventive action and measures, as well as by aiding and cooperating with other relevant agencies. To accurately register all complaints brought to them by a complainant or his representative. To register and investigate all cognizable offences coming to their notice through such complaints or otherwise. To create and maintain a feeling of security in the community. To provide as first responders all possible help to people in situations arising out of natural or man-made disasters. To collect intelligence relating to matters affecting public peace, all kinds of crime including social offences, communalism, extremism, terrorism, and other matters relating to national security. Disseminate the same to all concerned agencies besides acting and as appropriate on it themselves. बहुत सारे हैं ये, वो आप खुद पढ़ सकते हैं. ऑल इंडिया मॉक के बारे में हम ऑलरेडी डिस्कस कर चुके हैं. Right, so we have a quiz also. Let us start. Which court is responsible for imposing any sentence including capital punishment? हमने पढ़ा था ये. Court of Session, right? Then, what type of offences require immediate action and do not require a warrant for arrest? बहुत ही आसान है. ओके, नॉन बेलेबल ऑफेंसेस. इन सब में तो नॉन बेलेबल ऑफेंसेस ही उस कैटेगरी में आएंगे. ई क्यों है ऑप्शन? What is the purpose of an anticipatory bail under section 438? To request for an arrest warrant against the accused, to seek compensation for the victim, to prevent the arrest of a person who anticipates being accused of a crime. This is correct. C. Right? Which document is not considered as a substantive piece of evidence in a criminal trial? And the answer is FIR. Right? It's given in the passage only. ये one word question है जो पूछे जा चुके हैं एग्जाम्स में, इसलिए आपको बताए जा रहे हैं. What is the function and role of the police according to the information provided? Solely focus on registering and investigation non-cognizable offences? No. Promote communal harmony, maintain public order. Primarily provide legal assistance to the accused? बिल्कुल भी नहीं. Legal assistance देना पुलिस का काम नहीं है. To protect only the life and liberty? ये भी काम नहीं है. ये तो बिल्कुल ही नहीं है. क्या बचा? B. B is the correct answer. Okay. To promote communal harmony, maintain public order. So that's it for today, guys. Thank you so much. We have launched comprehensive courses, the information of which I've already provided you with. These are full-fledged long answers and short answers available at your disposal. Do make notes of it and I shall see you again very soon. तब तक सब अपना ख्याल रखें. Take care. Goodbye. Thank you.